I thank the Chairman, sir, for the opportunity. It's a great day, a maiden speech on a subject that is very dear to my heart and a subject that can be as related to law as possible. So a maiden speech, I believe the chair is a little indulgent and gives a little more time, but I won't take much time. A maiden speech also has the protection of the House. It is freedom of speech in an absolute form. The member has a right to say on the first day whatever he wants. So, I would confine myself to the legality of the proposed legislation. And I will address the House and the chair, of course, from three standpoints: sub judice, overreaching the Supreme Court's order, and the constitutional validity. So there is some faint voice about impropriety, sub judice. As a layman, it is not sub judice. What is pending before the Supreme Court is the validity of the ordinance. What the House is debating is on the validity of a law.
Please. Would you please take your seat? No. Absolutely no. 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 Don't force me. The House was going well. One second.
All right.
Do you want me to go further? Please take your seat.
Mr. Chairman,
I
sir.
will not allow. This is not good.
Mr.
No one
Chairman,
was
sir.
interrupted. You suddenly rise. The House is getting enlightened. Trust me. Mark every word. The House is getting enlightened, as was enlightened by others also. Please go ahead, sir.
Mr. Chairman, sir. What is pending before the Supreme Court is the validity of the ordinance, and specifically two questions referred to the Constitution bench. That has nothing to do with what is being debated in the House, number one. Number two, this is for all the members of the House, and it has some importance so far as the relation between the judiciary and the executive is concerned. I would request all the members of the House to have a relook at Articles 105, 121, and 122. There is absolute freedom of speech in Parliament, and whatever a member says in Parliament cannot be questioned in a court of law. I do not find a similar constitutional provision restricting the debates in courts. What the courts cannot do under 121 is question the conduct of a judge in relation to a pending matter. The restriction that the House imposes on its own speech is self-imposed by the rules. And what do the rules provide? Mr. Chairman, sir, the rule says a member shall not discuss a matter of fact which is a court pending before a court of law. It's not a matter of fact that is what is being debated. It's a question of law. It is not even an interpretation of law. It's on a debate on law. Now, Mr. Chairman, sir, so where sub judice is concerned, the bill takes away 3A from the ordinance. To my mind, it's a perception, I may be wrong. To my mind, when 3A has been taken out of the ordinance and it is not there in the bill, the questions referred to the Constitution bench stands self-answered. Because if you read the order of the Supreme Court referring the matter to the Constitution bench, a copy of which I have got and I have read, my view is that the entire reference has been necessitated by the provision of 3A of the ordinance, which no longer exists. Therefore, it is the prerogative, the right of the members of the House to debate. The question of sub judice doesn't come. So far as overreaching or outreaching the order of the court, Supreme Court is concerned, very shortly put, the position in my perception is this. The state legislature makes laws for the states, the parliament makes laws for the union territories. For the National Capital Region of Delhi, which has a special status, the state legislature or the legislature of Delhi makes the laws on the state subjects, except 3. But as Mr. Jethmalani read out, by virtue of 239 3B, Parliament has a power to frame laws beyond these 3. And that is exactly what the bill is seeking to do. Therefore, there is no question of overreaching. And what has the Supreme Court repeatedly said? Paragraph 164, 2 conclusions. These are the 2 conclusions. The legislative, 164C, the Legislative Assembly of the NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries. In addition to entries in List 1, in addition to entries in the Union List, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD. This is the conclusion in paragraph 164. C, paragraph 164F, the executive power of the NCD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. So this is the conclusion of the Supreme Court. And therefore, now, what has the Supreme Court repeatedly held in the 2018 judgment and the 2023 judgment? Precisely this. And I'm very grateful for the fairness shown by the first speaker, Dr. Singhvi. If I'm not mistaken, what Dr. Singhvi said, the power of Parliament is not in dispute. He said it very fairly. The power of the legislative competence of Parliament is not in dispute. Then why would this law be bad? This law would be bad if it violates the fundamental rights, number 1. Number 2, if it violates any other provision of the Constitution, and if it violates the basic structure of the Constitution. Right.
Honorable members,
Yes.
I don't have to remind honorable members, it's a maiden speech. Yes, please. And the honorable member is making his point very rationally.
Sir,
it is one point of view.
I will take.
Well, the chair has taken a call.
I will take 2
I'm
minutes.
here with it. Sorry.
You have 15 minutes. You have 15 minutes.
Should we?
So far as
One sec. One
So
second.
far as violation
One second.
of
One second.
fundamental
Honorable
right is
member,
concerned.
Honorable member, one second.
So
One
far-
second. 1 second.
Yes.
This House should not set an example that an honorable member with huge experience in his matter is making a point. And every time you rise and tell me time is over. It is my authority on a maiden speech. Sorry. Honorable members, I have given adequate time to every member on the maiden speech.
Yes.
And I had every time pleaded with you to show respect. Merely because what the point is being made, it is required not to be registered, but to be digested. And you will have an opportunity to deal with it. We are getting input in this house from a very experienced legal mind. We got it from Dr. Singhvi. We got it from Mr. Chidambaram. We got it from Mr. Mahesh Jethmalani. We have to get also from Mr. Gogoi. Please, sir.
In any case, Honorable Chairman, sir, I have come to the end of it. Violation of fundamental rights. The only fundamental right that can be violated is perhaps Article 14, and that too, the limited part of Article 14, that the law is arbitrary. Is this law arbitrary? This doesn't appear to be so. The law may not be to my liking. That does not make it arbitrary.
Absolutely.
Next, does it violate the basic feature of the Constitution? Sir, I have to say something about the basic feature.
Please.
There's a book by Mr. Andarajuna,
Yes, yes.
the former Solicitor General, on the Keshavananda Bharti case.
Yes.
Having read the book, my view is that the doctrine of basic structure of the Constitution has a very debatable jurisprudential basis. I would not say anything more than this.
Does not suit the ruling party, sir, that is why.
I wouldn't say anything more. The doctrine of basic structure has a very debatable jurisprudential basis. In any case, Honorable Chairman, sir, what the bill provides is diluted form of what federalism, because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, asymmetrical form of federalism. And the third thing is, does it violate any other part of the Constitution? The Supreme Court mentioned about triple autonomy. What you have under the bill is a modified form of triple autonomy. The bureaucrat is responsible to a lieutenant governor, who is responsible to the Home Ministry, who is responsible to the House. You have a modified form. If you want a full-fledged federalism, which today is a basic feature, though I have my own perceptions there, you can go for an amendment, for a constitutional amendment, and make Delhi a full-fledged state. Now, the most important thing, Chairman Sir, is Article 239AA, starting from 1 to 7, is not under challenge before the Supreme Court. Challenge it. That is not under challenge. Therefore, in my respectful submission, my contention, the bill is perfectly legitimately valid. But I fully support Mr. Vikas Bhattacharya, who has been a very close associate of mine. What is permissible need not necessarily be right. In the House today, parliamentary democracy compels members to vote according to party dictates. Fine, I cannot quarrel with that. It's a small section of people to whom you appeal to their conscience. To me, the bill is correct, right? My conscience tells me to do something, I'll do it. But if somebody disagrees, his conscience must be left free. Thank you. I am honored. I'm privileged.